to lay people, when you use the word patents and talk about the patent system, most people's eyes just glaze over.
And understandably so, yes.
But if you had to get someone as passionate about our patent system as you are, and as you inspire your students to be, what would you explain to people about what's so great about America's patent system?
Well, what's really awesome about patents, and this is the key, right? Because even lawyers, their eyes glaze over when you start talking about patents, is it's about innovation. It's about all of the creation and the things that have made 21st century life literally a miracle. I mean, 50 or 60 years ago, if you had said to people that we would be curing cancer, some cancers, and we'd be treating viruses, and we would have devices in our pockets that we called phones, that you could access almost all of human knowledge, and yet we share cat videos. They would have thought we were crazy. And yet these are all innovations that we take for granted today, that are a part of our daily lives, and they were brought to us by the patent system and by the whole array of property right protections that are central to what makes America America, that we protect the fruits of people's labors, whether it's a farmer who's laboring on a field and growing crops, or whether it's an inventor like Tesla or Edison who are tinkering in the lab and trying to come up with the next great invention, such as electricity or light bulbs. And so it's key to what makes our lives who we are, and basically it's also fundamental to what has made America America.
For people who might not know the constitutional underpinnings and the role that our founding fathers played in designing our patent system, can you give us an overview? I know it could be the subject of entire seminars that I'd love to sit in with you with, and so would our audience. But
you're all too kind. But yes, and it's one of the great achievements and moral achievements of our founders, is that they recognize the importance of intellectual property, of securing to innovators and creators the fruits of their productive labors, just as much as a farmer and a mechanic or any other laborer in the world should have their fruits of their labors secured to them. So for the very first time in human history, intellectual property, patents for inventions, and copyrights, as I said in new artistic works, were put into our Constitution. As I said, that's the very first time in human history that had ever been done. And not only that, it's the only place in the entire Constitution proper. So the Constitution pre-Bill of Rights, the 1787 Constitution written by the framers, where you'll find the word right even used. They refer to the rights of inventors and artists to their creative endeavors. And from that, the very first laws that were created by the very first Congress in 1790 were the Patent Law of 1790 and the Copyright Act of 1790, because they knew that this was key and fundamental to protecting the property rights, the rights, as I said, of the productive labors of the new citizens of the new United States of America. And it was fundamental to the success of the American experiment in the following century. And it's been a key part of American exceptionalism, and it's what has made us great. It's not the only thing. You have to have the rule of law, you have to have the protection of rights, liberty, and property, and everything else, but it was an important key part of that whole process and that whole institutional framework that the framers created that made possible this country.
Explain to us, among people who study patents and write about them, there's the famous phrase and quote from Abraham Lincoln,
yes.
And I believe it's on isn't it inscribed above the patent office door, or it used to be, about the fuel of interest in the fire of genius?
Yes, so Abraham Lincoln, in a sense a founding father of the Republican Party, famously said of patents that it added the fuel of interest to the fire of genius, which is just this incredibly eloquent phrase, Jeffersonian, that captures perfectly the very essence of what it means to protect the productive labors, the inventive labors, the creative labors of the people who are creating all of the new products that make human life possible, that drive our innovation economy, that have that have raised our standards of living and have made modern life. And Abraham Lincoln also knew of what he spoke,
yes.
Because to this day, he is the only U.S. president to have actually received a patent. In fact, it was just this past May 22nd was the anniversary of the 1849 issuance of Abraham Lincoln's patent on a method of raising ships over shoals. So he himself was inspired. We already know he was a genius. And so he embraced the system. And in fact, it was in a speech where he was identifying some of the great achievements of mankind throughout history. And he actually put the patent system in that category of one of the great achievements of mankind, to recognize that the productive labors of inventors and creators really needed to be secured.
I love that phrase too, because I think it embodies something that a lot of people take for granted and that modern progressives detest, and that is the idea that the profit motive and patent rights go hand in hand, that in fact it is the fuel of interest that drives innovation in America.
Yes, I mean, this is exactly what Thomas Jefferson was getting at in the Declaration of Independence when he said life, liberty, and the pursuit of happiness, that protecting life, liberty, and property is what achieves happiness for individuals and creates a flourishing society. And it's exactly what the founders recognized about patents and copyrights. So in the Federalist Papers, James Madison famously writes about patents and copyrights, that this is where the public interest and the private good are one and the same. And you can see it repeatedly in the fact that our life today is made possible by the actions of innovators and creators who were pursuing their own selfish goals and coming up with new values that they wanted to see created and profit from them in the marketplace. And then from that, we as consumers obtain all of these benefits. And we're talking here about, the initial inventions like Eli Whitney's cotton gin and Samuel Morse's telegraph and Isaac Singer and Elias Howe's sewing machine, and Samuel Colt's repeating firearm, another famous example of American patent innovation, and then up through the 19th century and Thomas Edison's first practical light bulb and distribution systems, Tesla's invention of the whole electrical distribution system, and the Wright brothers' airplane. It was just the anniversary of the issuance of their patent on their airplane. Willis Carrier, who in DC, we very much appreciate air conditioning and his invention of air conditioning, all the way up through the laser and even disposable diapers. It's incredible patenting, and it's a very research-intensive area for which parents like myself are very appreciative of. So
exactly.
Everything today, and and the innovation that is spread into the market, made available to consumers, because these are property rights, which means you can take them into the market and sell and license and do whatever you want with them, just as like a farmer can sell or license their rights, or a landowner can rent out their house or live in it, or sell it to someone else to use it for manufacturing or commercial capabilities. The inventors could do the same thing with the property rights that they obtained in their creations, and that's what drove the innovation economy, drove the market, drove economic growth in this country.
So I want to bring this up to modern times.
Yes.
And I'd like you to explain for us the concepts of first to file versus first to invent, and why this is important in the policy discussions now about patent rights.
Well, it's very interesting you say bring up to modern times, and I know why you said that, because we recently shifted through legislation that was adopted by Congress in 2011 from a first to invent to a first to file system. But actually, it's an historical issue, and it's very important. It's a key part of what has made America unique. Again, part of American exceptionalism. The United States adopted a first to invent approach. In the Constitution, it says, the exclusive right shall be granted to the inventor. And this was explicitly in distinction with England and other countries that had patent systems at the time, but didn't view them as property rights that were rightly secured and justly secured to the creator. They were viewed as part of economic policy of a crown or of a state, privileges granted to individuals, bestowed upon them. That was England's approach in the 18th century, and as well as France's and others. And we took a very different approach. We said, no, this is the individual who's created something, who's labored upon something, and this is their justly earned desert. So it was one of the key features that distinguished us. In fact, in the 19th century, American judges talked a lot about this distinction, and we knew about it. So for instance, Charles Goodyear, the inventor of vulcanized rubber, and not associated with Goodyear Tire Company, though. That was named after him about 40 years after he died, because he never manufactured. He was a crazy inventor. Right. He only licensed his invention. He just wanted to invent, so he profited by giving other people the right to manufacture and use his invention so he could continue doing what his passion was, which was inventing. He lost his patent in England because they had a first-to-file system, and he accidentally shared a piece of his rubber with an English scientist who stole his idea and beat him to the patent office. And they had a first-to-file system. He even sued in England. There was a lot of litigation about this in England, and he lost his right. In the United States, and Americans had great umbrage about this. And no, I mean, Goodyear was the inventor of this incredible achievement that, it drove the Industrial Revolution. I mean, rubber is in everything. And yet he lost his patent simply because they filed first in England, because it wasn't about the inventor there. It was about privileges granted by the crown for economic purposes. Whereas the United States was more about securing to actually the inventor, the laborer who created this new innovation. And so it really represents kind of a shift in recent years as we moved away from the foundations of this country in all other areas of our lives. The patent system has been impacted as well, and we moved to a first-to-file system similar to what we have in the rest of the world. In fact, that was the justification for it. We have to harmonize with the world, and those of us who were fighting against this saying, we don't need to lower our bar and become like the rest of the world. We should inspire the rest of the world to rise up to ours. By the way, the exact way we did in the 19th century. So this is a really cool story to tell. So the Crystal Palace Exposition of 1850, the very first World's Fair. Yes. We were just an upstart country, right? We were about 70 years old at that time. And when we had broken from England in the 1780s, we forget this history. We were poor, we were indebted, we were devastated by a war, we were primarily an agrarian society. England thought that we would soon become begging to be joined back in with the Commonwealth. 70 years later, just a mere 70 years at the Crystal Palace Exposition 1850 in London, we were marveling the world with our vulcanized rubber from Goodyear and our Singer sewing machines and our telegraph from Samuel Morse and our cotton gin from Eli Whitney, and Samuel Colt's repeating firearms, and so on and so on. And the world recognized, actually, wow, how did this happen? And many countries recognized it must be their patent system. And so actually, a lot of countries adopted our patent system after that in the 19th century. And so we actually inspired the world at that time to raise their standards and become better. And yet now it's the reverse, and we are lowering our standards and becoming like other countries that don't secure proper rights to inventors and innovators.
How did this happen that we went from leading in front to leading behind? It was the Obama administration, in concert with a lot of, this was a bipartisan deal, the American Invents Act under Obama, which he signed in 2011. And it was sold politically in a far different way than it actually works in effect. Mm-hmm. How did this happen, and how is it that so many Republicans are on the wrong side of this?
Yeah, that's a great question. It's not reducible to any one issue. Mm-hmm. It's a confluence of a lot of different factors. Intellectual property, like all property rights, have always been very, very controversial. In the 19th century, you find people attacking patents as monopolies. I mean, all of the great innovators that I just mentioned, Singer and Morse, Samuel Morse's telegraph, they were all attacked as horrible monopolists who are destroying the world, just like great industrials were attacked as robber barons. And our term today for patent owners is not robber barons, it's patent troll. Mm-hmm. That's the way that innovators and important participants in the innovation economy are attacked. You've always had this undercurrent of this kind of anti-property, anti-patent sentiment. It tends to be very populist in nature, and keyed in with several other factors, I think, in recent years. There rose in our innovation economy a significant number of companies who don't have business models that are based upon intellectual property of the sort of types like patents and copyrights. So a lot of the search companies and internet service companies rely upon trademark or trade secrets, and they see patents and copyrights as actually blockades to their successful business plans because they are pass-throughs to other people's content. And so if you have a property right on content, whether it's a technological innovation or a copyright on a song or a story or a photo, then that's a blockade to accessing that. It's really not. You can get the licensing rights, but they want to lower those because they have a very short-term perspective, I believe, and thinking what is in their interest and their success. And so you started to get a focus of a lot of lobbying in DC. Oh, the patent system is broken. This has become a phrase that one hears a lot. The patent system is broken. Of course, this is being written and said on the very technology brought to us by the patent system, our smartphones and our computers and the internet. And so you had the lobbying, you had this kind of sentiment, this anti-patent sentiment, this populist sentiment. And then I think a lot of Republicans became confused because they were told that there was a litigation problem. They were told that there were a lot of lawsuits, and it's actually not true. Our litigation rate today is actually less than what it was in the 19th century with respect to patents. But they were given the impression that there was out of control litigation and that this could be like tort reform. Oh, we can fix this, and we'll clamp down on these issues, and that will serve as a leverage point for more tort reform. It's not tort reform, though. It's weakening of property rights. It's, if you have the ability to sue someone for trespass for your land, just to take away your ability to sue for trespass on land is not tort reform. That's weakening your property rights, and they were doing the same thing for patents. Mm-hmm. So you had all these factors coming together, and what it's created is, for lack of a better term, a moral panic in DC about our patent system. The Supreme Court is issuing decisions that consistently hurt patent owners, that go against patent owners. The regulatory agencies under antitrust authorities have been going after patent owners, and of course there's been extensive legislation, not just in 2011, but bills repeatedly introduced that weaken patent rights in this country. And it's a real concern because we're losing our innovation edge as a result of this.
It seems that some sort of political or ideological stigma has been attached to inventors who vigorously defend their patent rights. Right. And so how is it that happened, that all of a sudden inventors became demonized for defending the fruits of their mind? I mean, yeah. where did this happen? And I'm sure there's like a huge sociological, political explanation for all of this. But as you've written about so extensively, mm-hmm. in that critical period of the first wave of inventiveness in American history, and the flourishing of that in the 19th century, the courts seemed much more forward-looking about how they should properly interpret the law to encourage innovation.
Right. In the United States patent system, as I said, was an inspiration to the world to adopt a similar system, and we've taken the lead consistently. So where other countries hesitated to protect innovation, we said, no, this is exactly what the patent system is for. It's to protect these productive labors that researchers and developers are engaging in, working at pharmaceutical companies and tech companies. And so when it came to, for instance, the biotech revolution and even the high-tech revolution, the two great revolutions of the last 20 or 30 years, we were the first country to step forward to protect these under patents and copyrights, and where the rest of the world hesitated. And this is why our system has been referred to as the gold standard. And very much now, our system is under threat. And in fact, I don't think you can say that our system is the gold standard anymore because of legislation like the American Invents Act of 2011, strangely called the American Invents Act because it was the exact opposite. And all of the Supreme Court decisions that have gone against patent owners have made it almost impossible to get patents on. Actually, the biotech and medical innovations and the high-tech innovations that have made our lives possible today. I think it really is just a triumph of rhetoric over fact. As I said, there's a moral panic in DC right now about the patent system. If you asked most people within Washington, DC, what do you think about the patent system? They would say, oh, it's broken. It stifles innovation, because this has been the lobbying position of a significant number of large companies that have been arguing vociferously this position for many, many years. Of course, property rights are not a key part of anyone who is left of center, whether you're liberal or far left or leftist progressive. You have a concern with property rights, and so just in the same way that the great industrialists of the 19th century were attacked as robber barons at the end of the 19th century, the great innovators today are being attacked as trolls, and the companies that make them possible are being attacked as trolls. And it really is kind of shocking, because if you go back to the end of the 19th century, the defenders of the free market were defending patents and property rights more generally. But today, people have gotten caught up in this false rhetoric about the broken patent system, and so they've actually joined with these attacks on the left. And it's killing our patent system. We are turning our gold standard patent system into lead, and it's killing our innovation economy. Venture capitalists are now they're going to countries like China. When you talk to companies working in the innovation industries, they no longer ask you if you have a US patent. Actually, the most important patent now is a German patent or a Chinese patent. The United States is no longer leading the country. And the problem with this is that you don't see the effects of this immediately. This is the problem with all regulations, and the problem with status policies, right? Is that they pass a massive new regulatory regime or a takeover of the economy, and then the next day everything is still working, and they say, see, sky didn't fall. But that's because the impact is not the next day. The impact is 5, 10, 20 years later, where people who are making the investment decisions now to come up with a new innovation are saying, it's not worth it to me to do this because I can't get protection. And so and of course 10, 20 years later, people have forgotten why this is happening now.
As is so typical, the government intervention ends up doing more harm than good.
Yes.
So we visited Anthony Maglica, who's the head of and founder of the Maglite Corporation, and he talks quite passionately about the patent fights that he had to undertake. And he says that his company spent upwards of $150 million defending his patents, both here at home and of course internationally. So to the extent that the costs of defending one's patent rights are threaten innovation, there's still nothing that's really that the American Invents Act or in this realm has done to help an inventor like Anthony.
Oh, in fact, it's the exact opposite. I mean, the American Invents Act created this new administrative tribunal at the Patent Office called the Patent Trial and Appeal Board. Patent lawyers refer to it by the acronym the PTAB. And whenever you hear people talking in those acronyms, you know you're in a bad place. You know you're in the administrative state where the alphabet soup has come to the patent system. And it has a kill rate of patents of anywhere from 70% to 98%, depending upon which of their administrative review programs that you are put into. And it's a heads I win, tails you lose scenario, because anyone can file a petition, and they're just deciding to invalidate the patent or not. So if you file a petition and you're wrong, nothing happens to you. You're out several $1,000s. It's about $30,000, I believe, to file it, but that's easy to raise for most companies and most public interest law firms that are dedicated to wiping out patents. And it's also just become a place of extortion. And so people are going to patent owners and saying, well, you better pay me or I'm going to file a petition against you at the patent office and have your patent invalidated. And with these massive kill rates, it's entirely understandable why they can make those arguments. And the administrative tribunal is completely out of control. I was talking to a lawyer yesterday about his experiences, and he was saying he was recounting to me how he was talking with one of the administrative law judges that holds these hearings at this tribunal. And he said, well, I have due process rights. And he said that the administrative law judge got very angry and said, you don't have due process here. This is not a court. I mean, this is America.
Yeah.
You have a property right that is recognized in the Constitution.
Right.
That has been protected historically by the Supreme Court under the due process clauses, under the takings clauses. This has been long recognized as constitutionally protected private property. And you have people at the Patent Office saying, no, this is just some regulatory entitlement. We can take it away just as easily as we grant it.
What a surreal nightmare. There are no more safes. There are fewer and fewer safe spaces for patent holders and inventors.
Right, yes. And there they need those safe spaces.
Right. When we actually need one.
Yes, exactly.
Yeah.
And, and this is a little unsurprising if one takes kind of a, unfortunately, a realistic or cynical view of kind of, you see the growth of the administrative state and the destruction of all of our rights and liberties across the board, right? We've lost our rights to our homes and our businesses, and regulations are strangling people who are trying to start companies and keep companies going, and individuals. So of course this is going to start impacting the patent system, and it has. The patent system hasn't been insulated from these horrible influences upon the American government and the American people.
So if there were a Mossoff 5-point plan for restoring vigorous patent rights and protecting, I don't want to use the word protecting, but encouraging innovation in the same way that we did when the patent system was established, what would it look like?
Wow, that's a great question. If I was Philosopher King,
yes,
I would easily, as a wish list,
yes,
right, I would get rid of the Patent Trial and Appeal Board completely. It is an exemplar of regulatory overreach of the administrative state, unconstrained, and destroying actual property rights and innovation in this country. I would take us back to a first to invent system. The very basis of what drove our innovation economy and made America the shining example on the hill, the shining city on the hill for the rest of the world to look up to. I would restore the basic rights of inventors to the innovation that they're creating, that the Supreme Court has taken away from them. So if you come up with a new molecule that treats cancer or identifies cancer, if you come up with a new computer program, that is legitimate innovation, the very type of innovation that our patent system is supposed to spur on by protecting it. So you said you don't want to talk about protecting, but it's the protection that incentivizes the innovation. They go hand in hand, just like the same point applies to all property, right? Why would a farmer till soil and spend all this time husbanding those crops, growing them over months? Well, because the farmer knows that the crops are his, and he can do with them what he wants at the end of the day. He can feed his family, he can sell them on the market. They're his property. And the exact same principles apply in the patent system. It's the exact same issue. We protect the innovation, the innovative labors of inventors and creators. And by doing so, we incentivize them. So I would take us back to, as I said, the first to invent. I'd get rid of the Patent Trial and Appeal Board. I would restore the foundations of protecting innovation. It's a very complex area. It's one of the areas where I said even lawyers' eyes glass over. It's called patent eligibility doctrine.
Okay.
It's what is actually basically patentable. It's a basic core requirement in the patent system. Because you can't patent like a rock that you find on the ground. That's not an invention. But isolating a molecule, or isolating, for instance, the DNA that correlates with breast cancer, which took them hundreds of millions of dollars to figure out, the BRCA1 and the BRCA2 genes. That is exactly the innovation that we should be protecting in this country, and that's what the Supreme Court said. No, a BRCA1 gene, that's like a rock on the ground. That's a fact of nature. You can't patent that. It's surprising. I would definitely restore that, and I would, and then finally, a big issue, which is kind of unrecognized by a lot of people, is that patent owners have actually lost their property rights in a really fundamental sense, and that is if someone is trespassing on your land, if someone comes onto your property, you can call the police and have them removed. And the legal way that is done is called an injunction. And starting in 2007 with a Supreme Court decision, the ability for many patent owners to obtain injunctions against people who are deliberately infringing their property rights was removed. And so this has forced them into a regulatory regime where a judge gets to decide what they will be paid as a royalty for the unauthorized use of their property. I mean, we're right back into de facto leftist progressive rate regulation of the early 20th century with railroads and trains, and gosh, it worked so well,
yeah,
right? Yes, there, and we are doing this to our patent system, the very foundation of our innovation economy and of our jobs and of our standards of living in this country.
So there's a raft of these sort of mini America Invents Acts sort of spin-offs, right?
Oh, yes, yes. Yeah. So just as it was tendentiously called the American Invents Act,
yes,
tendentiously called the Innovation Act and things of that sort, that are just, that all do the same thing. You know, they weaken these property rights, they make it harder to obtain them, they make it harder to license and commercialize them in the marketplace, thus getting the inventions to consumers through the marketplace. I mean, this is also something that is really key to property rights. So you talk property rights to people and they often think, oh, property rights, that's the domain of lawyers or capitalists. And they don't realize that, no, property rights are the mechanism by which new products and services are brought to you as a consumer. It's the bridge, because what people don't realize is countries are inventive. I mean, England was very inventive in the 18th century. In fact, the Industrial Revolution starts in England for that very reason, right? You know, James's Watt's, you know, steam engine, and many others. But they could not make that bridge from the invention to the actual practical, innovative technology that's in the hands of everyday people. The United States did that, and we did that because we provided that bridge, and that bridge is what we call in the law property rights, because it's the basis of that for someone then to go to a company and say, I want you to manufacture it, or I want you to manufacture a component that you'll sell to someone else who will put it all together, who I'm also licensing. And through this division of labor and specialization, I'm an inventor, you're a manufacturer, this person is a seller, we achieve efficiencies and we get the products into the hands of consumers. This is the reason why your iPhone doesn't say manufactured in Cupertino, it says designed in Cupertino.
Yes.
Because they embrace this. And in fact, this is a story I love to tell. The iPhone was actually invented in 2003, but you remember when it was actually released to the public? I know, it seems like we've always had it.
Yeah, right.
Yes, I know, that's the problem with technology.
2007?
Exactly,
yeah.
yes. Mm-hmm. Yes, that betrays both of our ages, I believe. Yes, 2007. Yeah. And I always like to make the point, so what do you think, like Steve Jobs was sitting there for 4 years saying, I'm the only person with an iPhone in the entire world? Yes. No, what was he doing for that 4 years? Well, he was setting up the value chain necessary to create this product, to get it in the hands of consumers. He had to go to DuPont and convince them to make Gorilla Glass, which is the special glass that's used. He had to go to the manufacturers who make the chips and say, you need to design these particular chips. And it was property rights, it was the basis of those contracts, those commercial exchanges, which made this complex system come together. And it took 4 years to get it together. And this is what's beautiful about the patent system, right, is that it incentivizes inventors to create, but it does even more, right, on the back end, because the back end of innovation, which is the front end that we see, which is because then it serves that bridge, because it's not just this monopoly privilege grant that's given to you by the government. It's actually this property right that you can engage in all of these amazing commercial exchanges and create entire new industries on the basis of a couple property rights.
I love this. It's a great way to wrap up as well, because there's a lot of hot air and bloviating in the Beltway swamp about what the technocrats and command and control architects need to do to revive American manufacturing in this country.
Yes.
And it seems to me at the essence of what you're saying is give people the freedom and protect that freedom to innovate by being able to capitalize on the fruits of their minds.
You know, the best thing that the Washington, D.C. can do, get out of the way.
Right.
And you know, the high-tech industry was made possible because They grew up in an unregulated environment, so to speak. They were the beneficiaries of the Reagan Revolution in the 1980s. I don't think it was in part a coincidence that the high-tech revolution really takes off in the 1980s. The biotech revolution really takes off in the 1980s. Now, there were some key court decisions that said you get patents and property rights in biotech innovation, and you get copyrights and patents in high-tech software innovation. But combined with deregulation and the freeing up of commercial activities, people had the freedom to engage in these innovative enterprises. And we are 20 or 30 years later, all living the benefit of this. But unfortunately, the kids today don't remember what made that possible.
Yes.
And so they don't. So they're now wanting their cake and eating it too.
Yeah.
Right. They want the fruits of their free enterprise in the free market, and they want their regulations and their administrative state too. But you can't have both.
Thank you for this enlightening discussion, Adam.
Well, thank you.
Really appreciate it. Yeah.